All right, is there anyone who's ready?
I'm ready, Judge.
All right, who's your client? All right, could I see the docket sheet for Cooper, please?
You bringing him up, Judge?
Oh, okay. All right, as soon as they bring him up, I'll take care of that matter. And Deputy Laura, could you make the announcement for Taboris Tremaine Warren Jr. in the hallway? I'm sorry, what? Oh, no, I have that.
You have Cooper?
Yeah. Oh, no, Cooper? Let me see. I thought you were talking about the other person. Yes, I have Cooper.
Okay.
You're welcome.
All right, Deputy Laura, was he in the hallway?
He's out.
All right, thank you. LaShawn, is it cold?
No, if the plan is negative. No. People are busy. That's not true. Yeah.
All right, Cooper, are you all ready?
Well, Judge, we're ready to ask for a few days on this case.
All right, Mr. Cooper, come down. Oh, so you're good.
You need Cindy?
Yeah, Judge.
Cindy, oh, yes, sorry, thank you. All right, and on the last person I sent you all, that's a judge's warrant. Oh, yes, you can. See, I always tell people if you have it, and don't need it, that's great. But if you need it and don't have it, that's a problem. And so what's?
This is an MTR, Judge. I just need a few days to get some witnesses here, or it's not a contested hearing.
Mhm.
It will be a plea of true, but with some reasons, and I would like to have some witnesses to, to present on behalf of my client.
Okay,
So I just need a few days.
all right.
If I could have maybe the 12th, could you give me a week on that?
Sure, and do you want them to appear by Zoom or no? State, would you have any objection to the witnesses appearing by Zoom if that's the only way defense can have them present?
No.
So
I think they'll be present, but that would be very nice.
okay. All right, the court is calling 2024 CR 008-984 and 2024 CR 5691, State versus Eric Lee Cooper. Can I have parties announced?
State, Your Honor.
Julie Pollock for Mr. Cooper.
All right, just one moment. Can I have a file stamp, please, for a motion to revoke? Mr. Cooper,
Yes, ma'am.
and each of those cause numbers, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Eric Lee Cooper Jr. who's placed on deferred adjudication in 2024 CR 008-984 for the offense of burglary of a habitation on September 23rd, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
And are you the same Eric Lee Cooper Jr. who was placed on deferred adjudication in 2024 CR 5691 for the offense of unauthorized use of a vehicle on September 23rd, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same allegation in each motion?
Yes, Your Honor.
All right, you may
Would
proceed.
you like me to go ahead?
Yes.
Violated condition number 4. In Bear County, Texas, the defendant Eric Lee Cooper Jr. Defendant there failed to report to the supervision officer as directed for the months of October, November 2024 in violation of condition number 4.
To each cause number, how do you plead to a violation of condition number 4? It's either true or not true. True? All right.
Waive the remaining violated conditions.
Any objections to the state's waivers?
No.
All right, did you understand by pleading true to violation of condition number 4 and cause number 2024 CR 008-984, the court could find it true, grant the motion, and sentence you up to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true in that cause number. And cause number 2024 CR 5691. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. All right, we can go off the record.
August.
Oh, August 12th, sorry, August 12th. All right, so we're gonna come back on August 12th. The state has agreed that if your witnesses are not able to appear in person, that they can appear by Zoom. All right, is there anything else?
Not
No,
for
ma'am.
state.
Okay, all right, thank you.
Thank you.
Thank you, Judge.
You're welcome. Oh. Yeah. All right, anyone else ready? John Thurnert? Hi, you probably need to call your attorney. All right, thank you. And Norma, did we give a date for Mr. Valle? I know they're coming back tomorrow for the bond matter. Yes. All right, so it's coming back tomorrow for the bond issue.
I left my water back there while I was helping
Sure.
Daryl. So we're running.
All right, no problem. Don't run. All right, Norma, I need a 30-day reset on Jamal Coleman. The cost number is 2019. Oh, counsel, do you need a copy?
Yes, I will.
All right, if you'll just. On that, she'll need a copy of the court's orders. All right, and Miss, so.
The orders, if that's okay.
Yes. All right, who is here on Christopher Bernal?
But I only have the UUMB page that we should take the requirements daily on as the other.
All right, and,
Or sets of paperwork for that, if I'm on this bill, on this representative.
all right, so is Michael here?
Not yet, but she could.
All right, thank you. Hello, counsel.
Good afternoon.
Good afternoon. So your client did not show his name was announced. So a warrant has been issued for his arrest, a judge's warrant, and he'll be remanded without bond.
Okay, Judge.
All right, thank you.
Thank you.
Bye-bye.
Yeah, we'll just.
All right, John Thornart. Hello.
Hey, Judge.
So thank you for dressing it appropriately for court. So today is jury trial and plea deadline date.
That's right, Your
All right, so jury,
Honor. Jury, yes, Judge. What I was going to say, though, I think it's important to explain to the court what's happening today. The state has made you offer based on certain information we've discussed, certainly compelling, Your Honor. What I would respectfully ask, I think it's important enough, is if we could maybe be held for Monday, because I do think that there's some things that need to be discussed between myself and my client and his family, and some other aspects that need to be talked about with the state. But I think it will go a long way toward resolution here, Your Honor, in all sincerity. So I would respectfully ask for that if at all possible. We'd be ready to go on Monday if it doesn't come to pass.
all right, I'll call you back tomorrow. All right.
Understood,
Thank you.
Your Honor.
Thank you.
Understood, absolutely.
Right, thank you.
Thank you for letting me these statements.
Sure, no,
No.
no, just sign the reset form and I'll see you all then. All right, thank you.
Good evening.
All right, you too.
It's over.
All right, thank you. All right, can I have the parties on Christopher Bernal? And there are no applications?
No, Your Honor.
All right, court is calling 2025 CR 002116, 2025 CR 006799, 2025 CR 006379, State versus Christopher Xavier Bernal. Can I have parties announced?
Rick Peña for the state of Texas.
Michael DeLeon for Mr. Bernal. Robert Gowan for Mr. Bernal.
And are you Mr. Bernal?
Yes, Your Honor.
Attorneys, in each cause number, have you received all discovery and did you review those with your client?
Your Honor. Judge.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Bernal, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsels, in each cause number, do you waive the reading of the indictment?
We do, Your Honor. We do as well, Judge.
State, in each cause number, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Bernal, in each cause number, did you review the court admonishments with your attorneys? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Judge. Yes, Your Honor.
Stating each cause number, are you proceeding on the indictment as presented?
In each case, yes, Your Honor.
Mr. Bernal, in the cause number ending in 1-6, you're charged with the unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number ending in 9-9, you're charged with evading arrest, detention of a vehicle. And in cause number, evading arrest, detention with a vehicle. And in cause number ending in 7-9, you're charged with continuous violence against a family member. Those two causes are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. In each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor. He has.
In each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
You? We do.
In each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
I do. Yes, sir. Yes, sir.
Mr. Bernal, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to the jury trial. And in cause number ending in 1-6 and the other cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, and the cause number ending in 1-6, according to your plea bargain agreement, punishment is to be assessed at 149 days in the Bexar County Jail under 1244. There are no applications. This will run concurrent with 2025 CR 006379. The state will take in consideration 2025 CR 005685, 2025 CC 004005. There's to be restitution, if any, to Olga Tobar. And there's to be no contact with Olga Tobar. And the cause number ending in 99, according to the plea, punishment is to be assessed at 6 years in the prison. There are no applications. This cause number will run concurrent with 2025 CR 006379. State will take in consideration 2025 CR 005685, 2025 CC 004005. And the cause number ending in 79. The agreement is for a $1,500 fine. Punishment is to be assessed at 6 years in the prison. There are no applications. This will run concurrent with 2025 CR 006799, 2025 CR 002116. State will take in consideration 2025 CR 005685, 2025 CC 004005. There's an affirmative finding of family violence. There's to be no contact with Justin Vasquez, Emily Torres, Samantha Hernandez, and Claudia Sanford. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea bargain agreement in each of the cause numbers?
Yes, Your Honor.
Defense, is that the plea bargain agreements?
It is, Your Honor.
State?
It is, Your Honor.
All right, did you review the waiver of appeal paragraph in each of the cause numbers? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Honor. Yes, Your Honor.
Councils, have there been any such motions?
No motions, Your Honor. No motions.
Then in cause number 2025 CR 002116, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 006799, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 006379, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Your Honor, with regard to all three cases, state offers into evidence, states exhibit 1 with all attachments. We have no objections, Your Honor.
All right, and state, have you spoken to the complainants?
We have, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
And each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Here you go. Sure. All right, in each cause number, the court is going to find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to abide by the agreement, Your Honor.
Anything you wish to say?
No, Your Honor.
All right, why are you doing this? So somebody gets upset with you, they tell you, hey, put the toilet seat down. And then you hit them while they're holding your child, who I'm assuming you claim to love. And then you have the other incident where you want somebody to make you food and they say they're not going to. And then that results in you hitting someone. How old are you?
I'm 25, Your Honor.
Are you able to make your own food?
Yes, Your Honor.
So why don't you do that? If you're in a relationship with somebody and it gets to the point where you're going to get violent with them, then you shouldn't be in that relationship and you're not ready for a relationship. All this could have been solved with conversations. And guess what? Nobody's obligated to make food for you. You're not a baby. I could see if you're a toddler because maybe you don't know how to cook your own food, but you're an adult male. And if you're in a relationship, whoever that's with, they are not obligated to make you any food. You understand?
Yes, Your Honor.
So what are you planning on doing with the rest of your life once you're released from prison?
I want to better my life. I just want to get out and work.
Be out where?
I want to get out and work and be a better person.
Mm-hmm.
I really do feel like I need help with my anger.
No, you do. I mean, there's a lot that you need help with. And if you don't get help for it, what's going to end up happening? You may meet somebody who is stronger than you, meaner than you, and they're able to meet your force with force that will not go in your favor. You understand?
Yes, Your Honor.
So when you're released from prison, you need to find a place that can help you with your anger. If you can't find a place, you come back here, then I will pick up the phone and call to help you. You understand?
Yes, Your Honor. Thank you.
All right. So in cause number 2025 CR 002116, the court is finding you guilty. The court is going to sentence you to 149 days in the Bexar County Jail under 1244. Give you credit for any time served. This will run concurrent with 2025 CR 006379. Take in consideration 2025 CR 005685, 2025 CC 004005. There's to be no contact with and restitution to Olga Tobar. And there's to be no residing with minors. And cause number 2025 CR 006799. The court is finding you guilty, sentence you to 6 years in the prison, give you credit for any time served. This is run concurrent with 2025 CR 006379. Take in consideration 2025 CR 005685, 2025 CC 00405. I'll order the therapeutic community. And there's to be no residing with minors. And cause number 2025 CR 00637. Court is finding you guilty. Court will sentence you to 6 years in the prison. Credit for any time served. there's a $1,500 fine. This is run concurrent with 2025 CR 006799 and 2025 CC 004005. There's an affirmative finding of family violence. There's to be no contact with Justin, Jesten, Vasquez, Emily Torres, Samantha Hernandez, and Claudia Sanford. And there's to be no residing with minors and the therapeutic community. Is there anything else from either side with regards to sentencing?
Yes, sir. I think that on the last one, there might have been a mix-up with the case numbers as far as which ones are running concurrent, and which ones are being TSC.
Okay, I'm sorry, concurrent with 2025 CR 006799 and 2025 CR 004005. Is that correct? And then taking consideration 2025 CR 005685 and 2025 CC 004005.
I believe the one that should be running concurrent with is 2025 CR 002116.
All right,
The first one that you, 006799. I apologize if it's,
oh, no problem. All right, I'm gonna read the numbers I have, and when I'm incorrect, just let me know.
yes, sure.
So this is the run concurrent with 2025 CR 006799. Is that correct?
Correct, Your Honor.
And it's also to run concurrent with 2025 CR 002116.
That's correct.
And taking in consideration 2025 CR 005685
That's correct, Your Honor.
and 2025 CC 004005.
That's correct.
All right, thank you. Is there anything else with regards to sentencing?
No mistake. That's for the defense, Your Honor.
All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it? And did you sign them?
Yes, Your Honor.
All right, and each of these cause numbers, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And also in cause number 2025 CR 006379, you're not allowed to own or possess any weapons or ammunition because it's an affirmative finding of family violence. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. Your life isn't over, right? I know you're going to prison, and going to prison is hard, but you need to better yourself when you get there. Otherwise, you're going to be right back where you are now. You understand?
Yes, Your Honor.
You're going to have to make some changes in your life. All right, good luck to you. Thank you. Okay, are they ready with him?
I don't know. They just didn't, I just turned in the.
All right, can you leave him? Let me, yes.
Okay. But you're not still ready for the interpreter.
No.
All right, do you have the dismissals, counsel?
I will. Yeah,
Thank you. Yes. Oh, can you come around here for a moment?
Judge, your rules is regular
All right, the court is calling 2025 CR 007420 State versus Mark Log. Could I have parties announced?
Jason Garahan for the state, Your Honor.
Kathy Compton for Mr. Locke.
And are you Mr. Log?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, I have, Your Honor.
And did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. This is an application.
Yes, it is.
Yes, it is.
Mr. Log, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Mr. Log, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
Are you a U.S. citizen?
Ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 8 years in the prison. There's an application for community supervision and the state is recommending community supervision. There's no application for deferred adjudication. There's to be a judgment satisfied in 2025 PF 20911, ignition interlock, driver's license suspension, DWI intervention, the MRT, you're to forfeit the firearm. There's to be a TAP evaluation and follow all recommendations of the TAP. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense,
Yes, Your Honor.
state?
Your Honor, I'm sorry, you might have wrote it down on here.
Mhm.
What are the amount of years?
8.
Okay, yes.
Okay. All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be 200 hours community service restitution, and you're to take all medications as prescribed. Did you understand those are recommendations from the state?
Yes,
And the
ma'am.
court does not have to follow those recommendations.
Yes, ma'am, I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, state exhibit number 1 with all the attachments.
No objection.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am, I understood.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court is finding there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We're asking to do so, yes.
Anything you wish to say on behalf of your client?
Your Honor, I would just ask that the court follow the plea bargain agreement.
All right, sir, do you have any children or grandchildren?
No, ma'am, I don't have any children.
Who do you have as a support system?
My wife, Victoria Ann Locke,
Okay,
and my mother, Mary Locke.
all right. And before this happened, were you employed?
I know I'm 100% disabled veteran.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 8 years in the prison, suspended and probated for 6 years. There should be regular reporting by Zoom or in person, regular random UAs, proof of employment or disability within 45 days, no employment as a home health care provider or minors. So if you provide your disability, that you're 100% disabled, then of course there will be no employment. So one of the two needs to be provided to probation within 45 days of your release. You understand?
Yes, ma'am, I do.
Judgment satisfied in cause number 2025 PF 20911. And with regards to the judgment satisfied, that cause number is not heard by me. So wherever that cause number is, they'll have to calculate the number of days you've been in jail and give you that exact number of days in jail for it to be judgment satisfied. You understand?
Yes, ma'am, I do.
Right. Ignition interlock until further notice. A 2-year license suspension. DWI education course. Victim Impact Panel Live. In custody, this is what I want done. I want a referral to felony drug court. Counsel, that should be completed soon. And also a referral to Veterans Treatment Court. If you'll contact either Veterans Treatment Court or felony drug court to see which one can see him sooner. Ms. Abrams, can you help her reach out to Herman?
Judge, I can do that. We just can't have 2 referrals open at the same time.
Okay, so felony drug court, they'll probably be able to see him maybe this week. Veterans Treatment Court, that usually takes longer.
Would that hang him up as far as remaining in custody?
Well,
and
Veterans Treatment Court, because they do it very quickly, I'm gonna have him in custody until that's completed. With the Veterans Treatment Court, that can be done out of custody because that takes longer.
So, given that he's 100% disabled and he is a veteran, judge, I would ask the court to allow him to apply or be evaluated for that one first.
For Veterans Treatment Court,
Yes.
then he's gonna have to be in custody.
Oh, I thought you said he could apply out of custody. So you're
He's
saying
staying.
he's staying? in
Yeah,
custody.
for felony drug
Well,
court.
then
it is.
whatever's the quickest.
All right, so we'll do felony drug court first. And if felony drug court doesn't accept him, then he can do Veterans Treatment Court out of custody. I just want him to get the treatment as quickly as possible.
Okay.
So,
So as far as, I've never had to do anything myself to get somebody into
Well-
to the drug treatment, the felony drug.
well, the
court.
drug court, all I have to do is sign a referral and I'm gonna sign that today.
Okay,
So he'll probably be seen this week because it's only Tuesday.
okay. So you don't need anything from me as far as
No.
that goes.
The
You just
Veterans
let-
Treatment Court probation has said they will reach out to them. And that's just if he's not accepted into felony drug court. Sometimes felony drug court will say, hey, I think he's a better fit for Veterans Treatment Court, but that will just be decided at that time. So we're gonna do a referral for felony drug court in custody. If not accepted, then it will be Veterans Treatment Court out of custody. And there'll be a TAP evaluation out of custody. 200 hours of community service restitution. And again, you have to provide your disability with regards to that if there's some issues with his doing community service hours. I'm gonna want 90 sober meetings in 90 days. Forfeit the firearm. And we'll do, Veterans Treatment Court should be able to address any mental health issues. Are you seeing a doctor at the Veterans Treatment Court?
Yes, ma'am.
I'm sorry, at Veterans Hospital?
Yes, ma'am, I am.
All right. So continued treatment at the VA
Yes, ma'am.
for mental health.
Yes, ma'am.
All right, probation, is there anything else?
This is, and then I also wanna know, do you want him to do the DWI education or intervention?
DWI intervention. And field visits 1 time per month for 6 months. Thank you. Is there anything else you need from the court?
No, ma'am.
All right. We can go off the record. Oh, no. Not off the record just yet. So I know this is a lot for you, but this is what I want you to understand. You're going to be out of custody before the week is out because felony drug court will have done their evaluation before then.
Okay.
If for some reason felony drug court, they'll contact probation or they'll contact me and they'll let me know that they think you're more suitable for Veterans Treatment Court. And then what will end up happening, if that's the case, you'll be released from custody and you'll have to make sure that you make all of their appointments because Veterans Treatment Court is completely different from probation. And they'll give you a date of when to show up and they're real good about having a case manager so they can contact you. If for some reason Veterans Treatment Court said, no, he's not a good fit with us, then you're going to have to do a TAP evaluation with probation. That is another different date. But in this court, probation is very good about contacting you and saying, this is the date of your TAP. So don't think just because you've done one, that means you don't have to do anything else. You understand?
Yes, ma'am, I do.
And if for some reason there's confusion on your end or probation's end about what you need to do, just let them know you're confused. If you feel they're not helping with that, you can always come back to court. You understand?
Yes, ma'am, I do.
Because the state wants you to succeed, I want you to succeed, and your attorney wants you to exceed at this probation, okay?
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, ma'am, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, thank you so much. I like your shirt.
Thank you, ma'am.
Yeah. All right, Vashawn, are you able to go over this with him now or?
It'll be after they'll hold them for me.
All right. All right, we're going to go on the record. Are you set up with him? All right, we're going to go on the record in 2025 CR 0028807, State versus Angel Miguel Cepedes. Can I have parties announced?
Actually, John's in for the state.
John Reitmeyer for the defense.
And are you Mr. Cepedes?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record, please.
Your Honor, the interpreter's name is Jorge Valle.
All right, thank you. You may be seated. All right, it's the court's understanding that a verdict has been reached. There are not to be any outbursts in the courtroom. If there are outbursts in this courtroom, you're going to be asked to leave and you'll only be called back if you are a witness. All right, Deputy Laura, if you could bring them in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you'll hand the verdict form to the deputy, please. Thank you. right, if the defendant will please rise. All right, the verdict form reads as follows. We, the jury, find the defendant, Angel Miguel Cespedes Ronda, guilty of the offense of aggravated kidnapping as charged in the indictments. And the jury also states, we do not unanimously find beyond a reasonable doubt that the defendant used or exhibited a deadly weapon, namely a pair of scissors and or knife during the commission of the offense of aggravated kidnapping. Does anyone wish to have the jury polled?
Not in the state yet.
All right, thank you. Everyone, please be seated. All right, ladies and gentlemen, I'm gonna have you go in the back and I'll bring you back out shortly. Everyone, please rise for the jurors. All right. State
Anything with judge.
So all that in this.
All that, yeah, is with judge. Limitation from judge. Ready, Judge?
Yes. All right, so the jury,
All right, everyone, please be seated. All right, ladies and gentlemen, this is the second phase of the trial. We do have an interpreter present. Please remember my previous instructions about the interpretation. We are to depend and rely on the interpretation made by the interpreter. So the questions will be in English and the interpreter will translate. And the answer is the interpreter's translation. Does everyone understand? All right, state, you may call your witness.
Your Honor, before the state officially calls the witness, the state would like to enter in all the testimony and evidence to be for consideration for the jury during the punishment phase.
No objections, Your Honor.
Then that will be entered
Thank you.
with the previous objections, if any, that were made by defense.
Yes.
All right, state, call your witness.
State calls Dubiela Contreras Perez.
All right, you're still under oath. State, you may proceed.
Good afternoon.
Good afternoon.
I want to talk about how this has affected you.
Excuse me, I think the court reporter cannot hear. And do you have the square microphone?
I'd like to talk about how this has affected you. Can you tell the jury if you have any lasting permanent damage from the assaults committed on you by the defendant?
Yes,
Go ahead and tell us when you're ready.
may I read the letter?
At this time, just answer the questions that I asked, okay?
Okay.
Do you have any permanent marks on your body from the assault from the defendant?
Yes, ma'am.
What are those?
Una encima de mi ojo, en la ceja,
One above my eye, at the eyebrow,
y una en mi cabeza.
and one on my head,
Where on your head?
in the back part.
Do you see those every day?
Sí, señora.
Yes, ma'am.
And how does that make you feel?
Me hace sentir muy mal.
I
Me
feel
deprime,
very badly.
Me deprime.
I get depressed.
And why is that?
Porque recuerdo lo que sucedió.
Because I recall what happened.
How has what happened affected any relationships that you have now?
Desde entonces me alejé de mis amigos,
Since that time, I retreated from my friends.
no hablo con mi familia,
I don't speak to my family.
ya no sonrío. Ya no sonrío.
I do not smile anymore.
La vida no es igual.
Life is not the same.
How so?
I'm sorry?
How is your life not the same?
Todo esto para mí ha sido difícil.
All of this for me has been difficult.
No es fácil verme al espejo por la mañana cuando me levanto
It's not easy for me to look at myself in the mirror when I get up in the morning,
o ver que mi hijo me mira llorar y no poder decir por qué.
or see that my son sees me crying and I cannot tell him why.
Tengo que
I have to
tengo que
I have to
a veces tomo pastillas para dormir porque tengo pesadillas.
sometimes I take sleeping pills to be able to sleep because I have bad dreams.
Y no es fácil porque
It is not easy because
no me gusta hablar sobre lo que sucedió.
I don't like to talk about what happened.
A veces yo misma me pregunto qué fue lo que le hice.
Sometimes I ask myself, what did I do to him?
Porque yo no fui mala mujer con él.
Because I was not a bad woman towards him.
Yo intenté ser lo mejor.
I tried to be the best.
Yo incluso dejaba de hacer cosas para mí con tal de atenderlo.
As a matter of fact, I stopped doing things for me to be able to take care of him
Para que él se sintiera en familia.
so that he would feel as a member of the family.
Y aún no encuentro la justificación.
So I cannot find a justification for this.
And how else has this affected you?
¿Cómo más le ha afectado esto? ¿Qué otras cosas le ha afectado?
Al ir a las tiendas,
When I go to the stores,
me asusta, me cuesta mucho salir con mi hijo.
I get frightened and it's a lot difficult for me to go out with my son.
No vamos al parque,
We do not go to the park.
no vamos a piscinas,
Huh?
no vamos a piscinas
We
ni a
do-
playas.
We do not go to swimming pools or the beach.
Incluso su campamento de la escuela no lo llevé por miedo.
As a matter of fact, I did not take him to his school camp because I was afraid.
En la calle no puedo ver un carro que sea Honda azul.
On the street, I cannot see a car that would be a blue Honda
Porque recuerdo sus palabras.
because I recall his words.
Una cosa es decirla y otra muy distinta es lo que yo siento.
One thing is to say this, and another one is to feel what I'm feeling.
mientras que él continuó con su vida como si nada hubiera pasado.
While he continued with his life as if nothing had happened,
Yo tuve que cambiarme de residencia hasta 2 veces
I had to change my residence 2 times
y cambiar a mi hijo de escuela
and change my son from school
porque no sentía paz,
because I did not feel peace.
no me sentía tranquila.
I did not feel at peace.
Has this affected your romantic relationships with
Tu
anybody?
relación romántica con alguien más.
Sí.
Yes.
How so?
Afectado, sí.
Ahora creo que me lo pueden volver a hacer.
Right now, I think it could be done to me again.
So have you had any romantic relationships since
¿Tiene
it
alguna
happened?
relación romántica ahora?
Sí.
Yes.
And in that relationship,
Esa relación.
are you saying that you're still scared that this could happen again?
Dice que usted piensa que le puede pasar de nuevo.
A veces lo pienso.
Sometimes I do think that.
Have you seen this affect your son at all?
¿Usted ha visto que esto le ha afectado a su hijo? en algo?
Mi hijo no sabe lo que sucedió.
My son does not know what happened.
Está muy pequeño para entender.
He's too young to understand.
Él no entendería por qué su madre llora por las noches o por qué grito dormida.
He can't understand why his mom cannot sleep at during the night and why I scream while sleeping.
Is there anything else you would like this jury to
Algo
know
más que usted quiere que el jurado sepa
about how this has affected
acerca
you
de cómo se le ha afectado,
that you haven't said yet?
que todavía no ha hecho.
Aunque continúe yo
Even if I continue
con mi vida o tratar de
with my
seguir
life
con mi hijo,
and try to go on with my son,
aunque lo oculte por dentro de mí,
even though I hide it inside me,
esto no lo puedo borrar.
I cannot erase this.
Estaba tratando de olvidarlo,
I've been trying to forget it,
de ya no acordarme de lo que sucedió,
to not recall what happened,
pero no he podido.
but I have not been able to.
Fue a la iglesia, incluso le pido a Dios que me ayude a perdonarlo,
When I go to church, I ask God to help me forgive him,
pero no puedo.
but I can't.
Algo como esto nadie se lo merece.
Something like this, nobody deserves this.
Yo creo que ninguna persona merece pasar por esto.
I don't think any person deserves to go through something like this.
Sentir miedo hasta de ver un carro, eso no es justo.
Feel afraid to even see a car. That is not fair.
Okay.
No es justo vivir así
It's not fair to live like this
y pensar que él pueda pasar por encima de la ley.
and to think that he can go above the law,
Que él sigue libre como si nada.
that he's still free as if nothing had happened.
Okay. At this time, Your Honor, the state would pass the witness.
All right, defense.
Ma'am, I believe you said, excuse me, the other day that after the incident,
Angel took you home, is that correct?
La llevó a su casa, ¿es cierto?
Sí.
Yes.
And is that still your testimony now that
Eso es testimonio.
he
Ahora,
took you home after the incident?
que la llevó a su casa después del incidente.
Sí.
Yes,
Él me llevó.
yes, he took me.
Okay. At the place you were living then,
El lugar que estaba viendo entonces,
did you have any concerns about
tuve
living
preocupaciones
there
acerca de vivir, de
in
vivir
terms
ahí,
of danger,
Perdón.
como peligro. I'm sorry?
in terms of danger
De peligro.
or feeling unsafe in your own home?
No seguro de su propia casa.
En aquel entonces no me sentía segura.
Back then, no, I felt safe.
Your Honor, we'll pass the witness.
Ya le paso el testigo.
Any further questions?
No further questions.
All right, thank you. You may step down.
No puede aspirarse.
Ladies and gentlemen, we're going to take a 3-minute break so that we can set up for the next witness. All right, everyone, please rise. All right, everyone, please be seated.
Todos pueden sentarse. Pues nada.
All right, State, are you going to have another witness?
No, Your Honor. At this time, the state would rest.
I'll have you rest in front of the jury, and then defense, do you have your witnesses present?
Yes, ma'am.
Sí.
Okay. All right, so defense, who will be your witness?
I beg your pardon?
Who will be your?
State will rest.
All right, defense, do you have any witnesses?
We do, Your Honor.
I'll call your next witness.
Your Honor, defense calls Vashawn Abrams.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. If you'll state your name for the record, please.
Vashawn Abrams.
You may proceed.
Thank you, Judge. Good afternoon, Ms. Abrams. Can you tell the jury what your current job title is?
Yes. I am a court liaison officer for Bear County Probation.
And that being in that position, are you familiar with the community supervision aspect of the programs and what they
Yes.
do? Can you tell the jury what probation is?
Probation is an alternative for being incarcerated. So it's a rehabilitation. We try to rehabilitate people instead of them going into the prison system.
Okay. And are there certain programs and requirements that are required while you're on probation?
Yes, there are standard conditions of probation that everyone that's on probation has to abide by. And then there are additional requirements, whatever the judge mandates.
Okay. Is the purpose of people being on probation more rehabilitation?
Yes,
And have you seen in your own knowledge, your own personal knowledge, have you seen positive effects of probation on people?
yes.
Is probation easy?
Objection to speculation, Your Honor.
Overrule.
Let me rephrase the question. With the requirements mandated by probation and whatever alternative, or excuse me, extra conditions added by certain courts, is it a strenuous program?
It can be.
It just depends on, would you say it would depend on the person?
Depends on the person.
Okay. Your Honor, will pass witness.
Good afternoon. So when you say it depends on the person, would you agree with me that some people are not successful on probation?
That is correct.
And as for probation rehabilitating the defendant as a goal, what does it do to protect the complainant or now victim?
Well, we supervise them so that there are parameters set for the victim to be safe, basically.
Is that typically like a no contact order?
No contact order if the judge requires it.
And that no contact order is basically just saying, don't have contact with this person or don't hurt this person.
That is correct.
No further questions.
Any follow-up?
Nothing further, Your Honor.
All right, thank you. You may step down. Defense, call your next witness.
Judge, could I have 1 minute or less than a minute to confirm?
All right,
complaint?
ladies and gentlemen, again, if you could step out in the hallway, just give us about 3 minutes. All right, if, please be seated. All right, if you can, defense, call your witness.
Your Honor, defense calls Angel Cespedes Ronda.
Right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Ángel Miguel Céspedes Ronda.
Ángel Miguel Céspedes Ronda.
All right, defense, you may proceed.
Thanks, Joe. Angel, tell me a little bit about yourself. Are you married?
Sí.
Yes.
Okay, and where does your wife live?
En estos momentos está en Odessa.
At this moment, she is in Odessa,
Odessa, Texas?
Odessa, Texas.
Odessa, Texas.
Do you have any kids?
No soy el papá, pero ella tiene un niño.
I'm not the dad, but she has a child.
With you living here and them living there in a different place, were you supporting them financially?
Sí.
Yes.
How much financially would you say?
De todo.
Everything.
Do you have any other relatives here?
Mi padre.
My father.
Okay. And did you support him also?
Sí.
Yes.
Okay. Do you know about how much you were supporting him financially?
Los gastos en la casa llegan, son casi unos 3.500 al mes.
The house is expensive. It goes up to about 3,500 per month.
Okay. Talking about the house, does your father live in that house alone?
Conmigo.
With me?
Okay, so you live with your father?
Sí.
Yes.
Okay. Do you know more or less about how much you were sending to your wife in terms of money?
No, no exactamente.
Not exactly.
Okay. Would you estimate more or less than $500 a month?
Más.
More.
What do you do for a living now?
Reparto comida.
I
de
deliver,
DoorDash
I deliver food, DoorDash,
y algunos cortes de pelo.
and sometimes some haircuts.
Okay. How often are you working?
Lo he perdido todo.
I've lost everything, almost everything.
Well, my question is, how many days a week are you working right now?
5 días de entrega de comida
5 days delivering food
por mi GPS, por el horario.
due to my GPS, my schedule.
How long is your schedule per day? Does it vary or is it fixed?
8 horas de lunes a viernes.
8 hours from Monday to Friday.
Do you get to pick up any overtime or other shifts?
No me permiten hacer overtime.
They do not allow me to do overtime.
When you're able to do haircuts, are you doing those on your days off?
En mi casa.
At my house.
Are you being paid for those?
Sí.
Yes.
If you are given the opportunity to be placed on probation, Are you gonna screw it up?
¿Usted va a meter la pata?
No creo.
I don't think so.
You don't think so?
Llevo un año portándome bien.
It's been a year since I've been behaving well.
Are you asking this jury to give you probation?
Libertad condicional, probation.
Yes.
Yes.
I'll pass it with.
State?
Good afternoon. How much did you make, or how much do you make a week from DoorDash?
¿Cuánto gana por semana con DoorDash?
Con la aplicación de Uber Eats,
With the app for
Me la
Uber Eats,
me la bloquearon por los antecedentes.
it was blocked due to my priors.
Con la aplicación de Spark Driver, unos 300 a la semana.
With Fire Driver app, about 300 per week.
About 300 per week,
300 por semana.
Sí,
Yes.
so that's about 1,200 per month.
Así, 1,200 por mes.
sí.
Yes.
Mr. Cespedes Randa, you understand the jury found you guilty
Fue culpable.
for aggravated kidnapping.
Por secuestro agravado.
Sí, entiendo.
Yes, I do understand.
Do you agree with that verdict?
¿Usted está de acuerdo con ese veredicto?
No,
No.
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 So you don't,
Así
you're
que,
saying you didn't do this,
que no lo hizo.
no.
No.
so you're not sorry for something you didn't do,
Así
right?
que no se arrepiente de algo que no hizo, ¿cierto?
Yo no lo hice.
I did not do it.
You said you've been behaving for about a year now.
Entonces dice que está portado bien por un año.
What did you mean?
¿Qué quiere decir con eso?
Perdí mi trabajo, perdí todo.
I lost
No
my
te-
job. I lost everything.
Do you think your good behavior excuses your bad behavior?
¿Usted cree que su buen comportamiento le excusa su mal comportamiento?
Mi mal comportamiento que no es comprobado.
My bad behavior that has not been proven.
No further questions.
Any redirect?
Nothing further, Your Honor.
All right, thank you. You may step down. All right, defense, call your next witness.
Your Honor, this time in defense rest.
State, do you rest?
We rest and close, Your Honor.
Defense, do you rest and close?
We do, Judge.
All right, can I have parties approach? All right, ladies and gentlemen, we've switched out the interpreters. Everyone, please be seated. And interpreter, you're still under oath. Thank you. I'm going to read to you what's the charge of the court on punishment. You do not have to memorize it. You will receive the original when you begin your deliberations. Charge of the court on punishment. Members of the jury, by your verdict returned in this case, you have found the defendant, Angel Miguel Cepedes Ronda, guilty of the offense of aggravated kidnapping as charged in the indictment. It is necessary that the jury assess the punishment for this offense. When a defendant is convicted of the offense of aggravated kidnapping, the defendant may raise and prove by preponderance of the evidence that he voluntarily released the complainant in a safe place. Release means that the defendant performs some overt and affirmative act that indicates to the complainant that he has been fully released from captivity. Voluntary means that the release was not the result of intervention or action by others. Preponderance of the evidence means the greater weight and degree of credible testimony or evidence introduced before you and admitted in evidence in this case. If you find that the defendant proves by preponderance of the evidence that he voluntarily released the complainant in a safe place, the special issue is to be answered by you in the affirmative. If you do not find that the defendant has proven by preponderance of the evidence that he voluntarily released the complainant in a safe place, you will answer the special issue in the negative. Now, bearing in mind the foregoing instructions, if you believe the defendant proved by preponderance of the evidence that the defendant, having committed the offense of aggravated kidnapping as charged in the indictment, voluntarily released Duvela Contreras Perez in a safe place, you must make an affirmative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for at any term of not more than 20 years or less than 2 years. If you do not believe the defendant proved by preponderance of the evidence that the defendant, having committed the offense of aggravated kidnapping as charged in the indictment, voluntarily released Duvela Contreras Perez in a safe place, you must make a negative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. You are instructed that your finding on the issue of whether the defendant voluntarily released the complainant in a safe place must be unanimous. That is, you must unanimously agree that the defendant either did or did not voluntarily release Duvela Contreras Perez in a safe place. In addition to imprisonment, an individual found guilty of the offense of aggravated kidnapping may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim, if any, but is paid to the registry of the court. The defendant in this case has applied on written sworn motion for community supervision, stating among other things that he has never been convicted of a felony in this or any other state. Our statute provides that where a defendant is found guilty of aggravated kidnapping and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend to the judge that the judge suspend the imposition of the sentence and place the defendant on community supervision. If the jury does recommend community supervision, it will be granted by the court. If there's any evidence before you that the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, You are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event that you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any matter. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, or system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law might be applied to this defendant if he is sentenced to a term of imprisonment, because the application of that law will depend on decisions by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you ready to proceed?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon, everyone. Again, thank you so much for your time and attention. First half of the trial is done. You all have done your jobs. You listened to all the evidence and testimony and you found him guilty. So now what you have to do, is to find the appropriate punishment. Okay? After listening to everything that you've heard and hearing exactly what he did to the victim, you're asking you all to sentence him to prison and not probation. State will reserve the rest of this time.
All right. Defense?
You've heard testimony from the complaining witness in this case that she was released at her home and she had no issues or complaints thinking it was an unsafe area. By her own admission, she was released in a safe space. Therefore, we tender to you, jury, that the punishment range should be reduced and now go from 2 to 20 years instead of what was originally charged from 5 to 99 life. With that said, we would respectfully request consider a wife, stepchild, and a father all living here, which the defendant said he helped support. Term of imprisonment for a long time would not only negatively affect client, however, it would also negatively affect 3 other people who do that. in order to give probation, the sentence you would give can be no more than 10 years. So we would respectfully request a sentence of no more than 10 years and a recommendation of community service. Thank you.
All right, State.
Yes, Your Honor. As the court said, you can consider all the evidence that you heard in the first phase of this trial. And you can also consider all of the evidence that you heard today. So we heard from Deshaun today, who described what probation is like, what those programs are, and that he would be under these conditions and supervision by the court. And I have great respect for that program with the right defendants. Okay? Those who know that they did wrong and want to change. Those who follow our social contract that we don't hurt one another, we don't assault one another, we don't take one another. And I asked Deshaun what protects the victim. And there's an order by the court that can be imposed, a no contact order. But that is just someone saying, don't hurt this person. That's already what we're living by. That's already what the defendant violated. I will say that the first step to recovery for any problem is admitting that there is a problem, right? You can't change unless you know that there's a problem to change. And that's why some people do well on probation, as Vishon said. Those who want to change, those who want to be rehabilitated. But as Vishon said, some people don't do well. I submit to you that those are the people that don't want to change, that don't think there's a problem, that don't think they did anything wrong. And that's what you heard on the stand today from the defendant. That he didn't do anything wrong. He's not sorry. How can he change and be rehabilitated for something he doesn't even think he did? You know who did it. You found him guilty. I will say also that we heard from the defendant that he makes about $1,200 a month, yet he sends $3,500 or spends $3,500 on his dad and sends $500 to his wife. It's a little short. But I think most importantly, what we heard from the defendant was a lot of I. I lost everything. This affected me. He's not thinking about what he did to Viviela because he still doesn't agree with you that he did it. But I ask you to think about the permanent marks on Viviela that she has to look at every day. The fact that she testified she lost friends and family. She doesn't smile. She can't explain to her son why she's so sad and wakes up screaming at night. She has to go to church to pray for forgiveness or for the ability to forgive the defendant and can't find solace there. She's lived with this for the past year since it happened, and she will continue to live with this. And so we do ask for prison time. The defendant has not admitted that he's done anything wrong. It's not someone who wants to change. And I do think we are asking for prison. In this case, yes, the complainant said that he did release her at her apartment. So that punishment range is 2 to 20. We asked for the 20 for what he did.
All right, ladies and gentlemen, we will send you back to deliberate. Everyone, please rise for the jurors. Hi, are you ready? Yes, sir. All right, Cindy, are you ready? Yes. All right, the court has received the following question from the jurors. For question number 3, we're asking for clarification on number 3. Does selecting recommended probation mean we relinquish prison time decided by jury? Have both parties had a chance to review the question?
Yes, Your Honor.
Yes, sir.
The court proposes the following supplemental charge. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objections to that answer or supplemental charge, state?
Not from the state, Judge.
Defense? Any objections to the court sending back the question and the answer to the jurors?
No,
Thank
Judge.
All right, we will go back on recess. All right. It's the court's understanding that there is a verdict in this case as it relates to punishment. There are not to be any outbursts in the courtroom. If there are outbursts in the courtroom, you'll be asked to leave the courtroom and not return. All right. Are all parties ready to receive the verdict from the jury?
Yes, Your Honor.
Yes, Your Honor.
All right.
All rise for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict as to punishment. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you will hand the verdict form to deputy, please. The verdict form reads as follows. We find that the defendant voluntarily released Juvela Contreras Perez in a safe place. We, the jury, having found the defendant is guilty of the offense of aggravated kidnapping, have also found that the defendant voluntarily released the complainant, Juvela Contreras Perez, in a safe place. We assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 3 years. There is no fine. And it states that the defendant's application for community supervision be denied. Does anyone wish to have the jury polled?
No, Your Honor.
No, Your Honor.
All right, ladies and gentlemen, I'll have you wait for me in the jury room and I'll come in and speak with you briefly. Everyone, please rise for the jurors. All right, defense. Did you prepare a trial court certification?
I did not, but
All right, if you'll, it's there. If you'll prepare that for me, please.
Yes, Your Honor. Victim would like to give victim impact statement.
Okay. Oh, please be seated. Yes. Bye. Have a good night. All right, Mr. Rhonda, the jury has requested that your punishment be assessed at 3 years in the prison. The court is bound to follow the jury's verdict. So the court will sentence you to 3 years in the prison. You'll receive credit for any time served. There is a $0 fine, and there's to be no finding of deadly weapon based upon the ruling of the jury. Is there anything else with regards to sentencing from either side?
Not from the state, Your Honor.
No, Your Honor.
All right. Mr. Rhonda, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Yes.
All right. You do have a right to appeal as this was a jury trial. Is there anything else from either side with regards to sentencing?
Not from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, thank you. It's my understanding that there's victim impact. So, Mr. Rhonda, the complainant wishes to say some things to you. I require that everyone treat everyone with respect.